Okay. Hello, everyone. Thank you so much for tuning in onto this stream. We are just literally starting right now. Thank you so much for tuning in. Today, I am joined by IT Goatee and also Hellville. I hope I pronounced that correctly. To discuss the Gingras. Hope I say his name properly. Affidavit, thank you so much for joining me, every single one of you. How are you doing? Let's
Let's
start with
start
you,
with you,
Hellville,
Hellville,
because
because
this is
this
the
is the
first
first
time
time
that
that
you've
you've
been
been
here.
here.
How
How
are
are
you?
you?
I'm doing all right. How are you doing?
I'm
I'm
good,
good,
thank
thank
you.
you.
I'm good,
I'm good,
thank
thank
you.
you.
And
And
IT
IT
Goatee.
Goatee.
Yeah. Welcome back to your channel. How have you
been?
been?
I'm doing all right. Thanks for having me back. I appreciate it.
No,
No,
it's all
it's all
good.
good.
Well,
Well,
the
the
last
last
time that
time
we
that
were
we were
here, we
here, we
were
were
discussing.
discussing.
It's
It's
on
on
Sunday.
Sunday.
It's on
It's on
Sunday.
Sunday.
We
We
were
were
discussing
discussing
the
the
entire
entire
context
context
behind
behind
the
the
rebuttal,
rebuttal,
the
the
show
show
of
of
bias,
bias,
I
I
should
should
say,
say,
by
by
David
David
Gingras
Gingras
to
to
say
say
that
that
Judge
Judge
Matter
Matter
was
was
prejudicial
prejudicial
towards
towards
Hmm.
was
was
showing
showing
preference
preference
towards
towards
Clayton
Clayton
Eshard
Eshard
in
in
her
her
rulings
rulings
and
and
in
in
her
her
previous
previous
rulings
rulings
and
and
her
our
recent
recent
rulings
rulings
to
to
have
have
Laura
Laura
Owens
Owens
be
be
recommended
recommended
for
for
a
a
trial.
trial.
Sorry.
Sorry.
My God, my bad, guys. Echo. Apologies, guys. I'm just seeing it. I'm just seeing it. Solo Dove, thank you so much. Oh gosh, here we go again. Another day of me being boomer. I am a boomer. I am a boomer. I am a boomer. Um, right. So where was I? Yes. We were talking. We were discussing, the filing that Gingras made. On top of him making in that filing, he was mocking Judge Matter, which was I could not believe it. I have to go back to it for a hot second because it didn't dominate Twitter or anything like that, but it got a couple of attention from individuals from LawTube. I think uh, Ian Runkle
Ian
mentioned
covered
Yeah.
a
it.
couple of
Yeah.
yeah. He mentioned a couple of things. Just this belief that an attorney could actually write this and send it to the judge saying, "Hey, you're being biased." So yeah. What did you make of? Because we're gonna go into the affidavit today and the response by
Hmm.
Clay in the chart. But let's start with you, IT Goatee. What did you make of the entire presenting towards a judge by David Gingras?
So the biggest thing for me was that when I first read it, I had a very big sense of panic, and it was he might have something here. It was um, because the idea that a judge could do a Google search and, as he said, do an ex parte investigation of evidence that wasn't presented at trial was something that, to me, as a layperson, felt very uncomfortable with because of the possible precedent that it could set. Then we ended up discovering that the Second Circuit actually ruled
Apologies for
recent
that.
or what was it,
Oh,
2000.
yeah, guys, if you hear sirens in the background, I do apologize for that.
They're coming for you.
Unfortunately, they finally discovered where I live.
Do you live
So yeah,
anywhere
sorry.
near Laura Owens? Because maybe they're coming for her.
I
Oh
didn't know
yeah,
you moved to Arizona.
yeah, but apologies for that. Continue.
No,
Continue.
so we discovered that in the Second Circuit, there was actually a ruling discussing a similar case where a judge did Google some particular fact, and that fact was deemed harmless to the case, but still able to be done by a judge to look up common things. And looking up the hours of a Planned Parenthood could be considered that kind of harmless error. And it was after we saw that initial posting that someone on Reddit posted a very long list of facts that say, okay, well, let's take this one little bit out and look at all of the things that Judge Motto ruled or found as a matter of fact, and compare, was Laura Owens's goose cooked already, and was this in fact harmless error? And a large number of people said, yeah, even if you take that entire bit out, she still perjured herself, lied on the stand multiple times, changed her story on the stand, still failing to disclose evidence and discovery for medical records pertaining to the pregnancy going back 5 years, as stated in the status conference in February. So even though our initial interpretation was that, holy crap, this is awful, once we digested it and thought about it a little bit more, it became, no, it's really not that big of a deal. And then with at least one of the rulings that we've gotten today, the court agrees. So
Yeah. What? By the way, what ruling was that today? I didn't even know there's a ruling today. What ruling did I miss now?
Another
Yep.
one of his motions was denied.
So if you go to Megan Fox's Twitter,
Oh, okay.
she posted the
I don't
one
know,
page.
Dave
I
Neal
don't
also
know.
released a video just recently.
Oh, in regards to it. All right.
Mhm.
Yeah.
Okay. How long ago was this, by the way?
This
just to have
morning.
an idea. This morning. Oh, okay. So, oh gosh, I literally missed this then, because this morning for you guys it's probably like midday for me.
Early
So,
afternoon for you.
yeah. Let me just try and find it.
Oh, she took it down.
What did okay. What did he say? What did he say?
Well, so it was that the
You're everything right?
yeah, I'm pulling it up. The court received and
okay.
considered petitioner's motion to vacate judgment, motion for new trial, alternatively motion to amend judgment, motion for leave to extend page account filed July 12th, 2024. It is ordered. The motion is denied.
Oh wow. Okay. So that was quick. Wait, so his motion to say the bias and all of that was filed
So this one wasn't, I don't know if this, because he posted two motions and they're very similar to one another.
okay.
So there's the initial one, which is the notice of change of judge with affidavit.
Okay.
And then there was the second one, which is this much longer one, 32 pages. And this is the motion to vacate judgment, motion for new trial, alternatively, motion to alter or amend judgment, and motion for leave to extend page limits. And it's 5 individual briefs all put into this one motion with, what he believes are facts about the reasoning as to why. But it also contains basically his bullet point list of things that he wants an appeals court to possibly look at if and when they decide to appeal.
Okay. Okay. That's I did. Okay. I did not know that he filed 2 motions. This is like everything about this guy is coming across to me as just someone as just can I don't know what to call it, because I literally only thought it was just this one filing, just this one that was put through. I believe it was on the 10th of July, already been rejected a week afterwards.
We haven't seen anything for that one, so
it wasn't even that one. So it wasn't even that one that was rejected. Gone.
Right. It's so that this motion is the one that's basically addressed to the presiding judge or the chief judge of the family court system,
Mhm.
and that's the one that we don't have yet. The one that
Oh,
he
okay.
filed after this one is actually addressed to Julie Mata, and she just denied it. So
Oh, okay. Gotcha. All right. Gotcha. Okay. So this right
I was
here,
just
we got.
thinking the
Sorry.
whole time.
Yeah. Yeah. Go on. Sorry. Go
I
on.
was just thinking the whole time reading that, like, I was just thinking of Megan's button, denied, sit down. Like, it was like swift denial. I
right?
love it.
Yeah. I mean, yeah. Like that's what I thought. I thought it would at least take a while to at least gather together what he was challenging. You know, the rebuttals for it. So I would love to read the whole order and see what she had to say because I didn't think we'll get edition in this early. I'll just be honest. I really didn't think so. But I think this is what I was looking
It's
for.
very
That's the one.
short. It's very,
Yeah.
very short.
Um this right here is the affidavit for of David Gingras. As we said, we were gonna go through it for in today's stream, which we are doing. But if you want the background to the case as well as a lot of context provided, go and check out the previous stream after this one. Make sure you hit the like button as well. I didn't think. Well, I mean, I did have an idea, but I was joined by Bruce of Oregon. Oh, sorry, from Oregon and Hey Bells, and they were pretty much filling in the blanks, and I was even learning things of. I didn't even know even existed. I personally thought I caught up with the case, and turned out last week, nope, there is a lot more here that they are pulling. That if you did
Yep.
come in when you did come in, when I did come in, not you, but me personally, when I did come in, if you came in at that time, you are going to miss that, and you are not going to get the full picture. So if you want to go get a full background, go check out that stream. So this is the affidavit here,
You can
and
never be caught up on this case. It just
Mhm.
keeps going.
Oh, that is so encouraging.
Sorry.
You're cool, you're cool. So this was what he created to have shown demonstration for all of the assertions that he was making in the motion. I'll just read it. I think we should start from paragraph 20 or 21. No. I think, yeah, that's talking about his time in the. I think this is it. Okay, okay. All of the previous ones is talking about a chart in the Bachelor. So now, paragraph 26. Let's read from here. It says, in addition to be widely covered by traditional news outlets, this case has also received massive attention on social media, including sites like Reddit, Twitter, and YouTube, among others. He's trying to set the scene to show a smear campaign, that terrible, gruesome Gamergate esque thing
Well,
that he's
it's not
trying
even
to
that.
pull.
All he's trying to do is set up the people are invested in the case, and then
Mhm.
they post on my blog, and it's them posting on my blog this idea that Planned Parenthood in Los Angeles isn't open on Sunday. So that's how he's getting the facts to lead towards that. And it would be a matter of Judge Mata couldn't be objective and know this particular fact because it wasn't presented in court, and she would have had to have found it after the court hearing because that's when his client changed her testimony on the stand.
But it was also found
Yeah.
that in some document that was posted at least a month before the trial, I believe, that there were people saying on Twitter or somewhere else that the locations that she was talking about weren't open on Sunday. Whether that's factual or not, I don't know. But as I said on Lauren's stream, you know, just because a facility is open on Sunday doesn't mean that the service that you requested is available on Sunday. You need particular
Right.
technicians. to perform an ultrasound. So the ultrasound techs might not be there. I would imagine that on most Sundays, probably those kinds of techs wouldn't be in a Planned Parenthood anyway. But like they might have, whoever said it might have been wrong, but she probably thought she read it somewhere. I mean, you know, there's 5 million pages that have been presented in this case. So who knows where anything is.
Right, and that's a very good point that you brought out there, Hellville, because end of the day, like some places open up and have limited services being offered. Some can, yeah, that's actually a very good point, because if it's not there, it's not there, but it might still be open.
Yeah, they
Um,
might be able to prescribe birth control on Sundays, but maybe not perform ultrasounds, you know, stuff like that.
right,
So,
absolutely, that's a very good point.
Yeah, so we know that the Orange and San Bernardino County locations are open on Sunday, which made it even weirder that she would change her story to "I went to the one in Los Angeles."
More traveling time. She just
wild
wanted to
goose
travel
chase.
someone.
You're
Yeah,
like a wild ultrasound chase.
Yeah,
funny girl. For instance, anonymous fans of Clayton have created social media pages focus on entirely on this case, including a Twitter account using the hubristic sobriquet. I've learned a new word. You know what? Let's find out what that word means. Define sobriquet, because I'm sorry, I don't know what that means. Sobriquet. Oh, a person's nickname. Okay, fair enough. Did not know that. That is a very interesting thing to learn today. Sobriquet,
He could
justice
have
for
probably
Clayton.
just used the word handle.
Yeah,
yeah, or
as
pseudonym.
as he rightly suggested here, hubristic. You can also question his use of sobriquet as hubristic as well, because it seems like that, like that's how he's using it. Anyway, that joke didn't land too well. The Justice for Clayton Twitter account has posted obsessively about this case nearly 3,500 times. You are actually counting. And one example of which is shown below. 4th of July post by Clayton's Justice. In
It's actually funny if you read the
uh,
text.
wishing. Oh, okay, thank you. It says wishing a happy and safe. I like the word safe there. 4th of July to everyone but Laura Owens and David Gingras. I don't see what's wrong with it. You can choose who you want to wish a 4th of July to.
He's butthurt.
Yeah, he's super mad.
I don't.
Yeah,
Why
he's
would
just upset. His feelings got hurt, you know. But he did the same thing to Dave Neal. He literally said, I'm here to represent your right to free speech to everyone except Dave Neal. Like on his Twitter,
Bio.
what's it called? Bio.
Mhm.
Like, and now he's getting butthurt because Justice for Clayton literally turned the tables on him. Sir, stop crying.
So basically, he can dish it out, but he can't take it. Basically, he can't.
Yes.
Correct.
Fair enough. Paragraph 27. In addition to posts on Twitter, anonymous fans of Clayton have created websites devoted solely to this case and to promoting their belief that Clayton is somehow a victim who deserves justice. One such pro Clayton fan site is justiceforclayton.com, which contains copies of all or substantially all pleadings filed in this case. This site also contains a one-sided narrative which highlights only the facts favorable to Clayton's version of events, while carefully avoiding any discussion of facts unfavorable to Clayton's narratives. I don't know, man. I think it's pretty. I
She doesn't have
don't
any
know.
facts.
Yeah.
I was
How can anyone present facts for her if she doesn't have any?
I was literally about to say. I mean, just because it's raining and pouring, you don't have to lie to everyone in the planet that it's actually been a sunny day. I mean, if it's raining, it's raining.
Yeah,
There is
exactly.
nothing you
Yeah,
can
it's
do.
raining.com is allowed to post that it's raining when it's raining out, no matter how much the sun says, hey, it's actually sunny. Like,
Yeah,
what?
that's oh Lord. So moving on. In addition to social media posts from his fans, Clayton himself has been extremely personally active in publicly promoting this case, giving countless media interviews in which he tells his side of the story, which I believe we should cover one of those interviews in one of these streams one day, hopefully. Clayton's attorney, Mr. Woodnick, has also published statements regarding this case, including a press release issued on March 7th, 2024, in which Mr. Woodnick accused Laura of fraud, suggesting she has been accused of fabricating pregnancies, doctoring medical evidence as a means to extort relationships several times dating back 10 years. I mean, that's what she actually did. But anyway, in an attempt to respond to some of this one-sided narrative, acting at Laura's request and with her written permission, I have occasionally posted comments about this on case on online, primarily my personal website and my Twitter account. The purpose of these comments has been primarily, if not exclusively, to respond to information being circulated about this case by Clayton, his lawyers, or his fans or supporters. When I post comments on either my personal
He says
website,
occasional.
Hmm? Sorry, go
He
on.
says
It's not
occasional.
occasional. It's like 500 tweets a day, and it's like, you know, a blog post a day. I mean, it was at some point. So occasional is the wrong word.
Yeah, he stopped posting after July 19th, but he was posting vociferously.
Oh gosh, I can't believe it! Yay! Check it out. Dave Neal and Megan Fox made it onto the affidavit.
Megan
Yay!
was
Before
super
this,
upset about this.
If
uh,
that's even her real name.
Megan doesn't
Oh,
like
God.
the idea that she shows up in a court filing for something that she's covering, and so this was the first time that this happened. So she got really upset about it, but
Oh wow.
it is what it is.
Okay. In that case, I would frame my word to infamous. Then I'll say infamous instead. Infamous appearance on this court filing. It says before discussing the specific issues and conduct giving rise to Laura's request to disqualify Judge Matter, it is important to understand some of the other participants who will be mentioned further below. Two such participants are individuals named Dave Neal and Megan Fox. Guys, also do not forget to like this stream to of course help out with the YouTube algorithm. Thank you every single one of you that are tuned in today. Let me read a couple of the chats out. Ron Launchinger says typical bully behavior can dish out, can't take it up for himself. Yeah, I believe I said that. Solo Dove, could the judge have talked to the witness from Planned Parenthood? Guys, who would you guys want to answer this? IT Goatee, Hellville?
Yeah,
Either
I
one of you.
responded to him, but she couldn't have. You can't contact a witness ex parte. That's vehemently against the
Okay.
rules. That's one of the reasons why the judge in the Young Thug trial got him, the judge to
Sure.
be removed from
Recused.
the case
Mm.
because he contacted and discussed with the judge, the prosecutor, and the witness in an ex parte meeting.
Okay. Yeah, that's a very good point. Mrs. Brightside 15 says, yeah, the denial was to this motion to vacate judgment, motion for new trial, alternatively motion to, okay, that's what the denial was all about. Thank you so
Yeah.
much, Mrs. Brightside, for that little bit of tidbits. I appreciate that. And thank you everyone that have liked this stream, or if you like streams like this and more, and want to see updates of future cases that we might cover on the channel, make sure you consider hitting that subscribe button as well. Let me go back into reading this. So I do not personally know either Dave Neal or Megan Fox, but during the course of this proceeding, I have become familiar with them, goes on to discuss their YouTube channel. Goes on. Yeah. Why did he bring it up? Bring that up? Is it because of why did he bring them up? I'm not seeing why you should. He's not making any arguments, so I'm confused. I
Because
think what do you know?
both Megan and him were at the trial, and it
Okay.
was out at the media van that Dave brought in where one of the comments was made by someone named Hava to the effect of Judge Mata's father was in the courtroom in the overflow room, and that's when Dave said, "Oh, we don't want a mistrial here," in a joking and manner, but so he's laying the foundation for those personalities. The reason why they're there and why it matters is because it was at this media circus, or whatever you want to call it, was the public participation in this case. And that's where her father, or Judge Mata's father, comes in to see what was going on. And we don't know, one, if he was there, two, the reason for wanting to be there, but it's all heard from hearsay evidence from multiple degrees.
And also, like, her father's allowed to attend a case, but yeah, we don't know if that was actually him or if that was just someone. I mean, they could have hired someone to say that in order to like do this. So like, we really don't know, beyond the benefit of the doubt or whatever. It's just such a ridiculous claim. But yeah, like bringing Megan and Dave into it is just trying to throw like spaghetti at the wall to see what sticks. It's just ridiculous. And I think the original motion was like 211 pages or something, like 211 pages of repeating the same crap over and over again, none of which makes sense.
No, so one of these motions was 211 pages, but that's because he attached the transcript to it, which was 140 pages. And then in addition to that, there was also the judgment, which was another like 16 pages.
Okay.
It wasn't all the one thing.
Which motion was this? 200 pages long. Was that the initial? What motion was that?
I think that was the initial one
requesting
here.
to have all of the judgments vacated or something, I think.
Oh, okay.
That one was.
That does make it. I mean, 200 pages is still a lot of pages, but
right. But when you add
140
140 pages of transcript, that's the reason why it's so long.
Right.
Sense.
So this is what he has, well, at least produced to say is demonstrative of pre-trial judicial bias. He goes on to say, so shortly after I became involved in the case, moving on. Specifically, immediately after Laura retained me to represent her in this matter, I attempted to obtain a copy of a file from a previous counsel. Unfortunately, Laura's prior counsel did not promptly respond to this request. This made it impossible for me to respond to a motion to compel filed by Clayton before I was retained. Because I could not respond to the motion to compel without a complete copy of Laura's file, and because Mr. Woodnick refused to agree to an extension of time, on April 1st, I filed a lengthy and well-supported motion seeking an extension of time to respond to the motion to compel. Okay.
At least he admits it was lengthy.
But it's funny because in previous motions, he says, this case is very simple. And then in one of these ones, he goes, or I think it's the next motion that he says, for a new judge, let me explain this very difficult case. It's like
he says it all within the same document.
Yeah.
He says really like up in the beginning towards that document, it's such a simple case. And then he repeats it again a little further down in that document. And then, towards the end, he's like, oh yeah, this extremely complicated. Well, which is it? Is it complicated or simple, sir? Cannot be both.
Yeah. Right. Okay, so this this was, I believe this is where he's gonna make a demonstrative finding. So this was where I said he best include this in the previous stream. I said he best include the transcript from the trial to show that this guy never said anything of the sort. He never said, I forgot what he said. But basically he was denying that one of the doctors or something like that was saying something in regards to the store being open or something like that, which is what the judge was referencing. So I was hoping that the transcript will be here. So if it's not here, I'll be very disappointed in David Gingras for not providing that.
So it's not in there, but it might have been in her report. But we never got the full copy of the report. We only have partial of the report. So she might have said it in one of the pages we are not privy to, which David Gingras Gangrene didn't post.
Gangrene. What were you gonna say? Sorry, IT. Brad. Sorry.
No, it's just so it comes in because he's saying this fact is not included anywhere. So he can't point to anything that says that it's not there because it's the judge who put the fact in without the supporting evidence of things in there. And when we get this ruling, we're hoping that it either points to a spot where it actually says where it is, or it's going to be a single page denial of the entire brief, and it's going to say we received the judicial notice for change of judge and the reply brief, and therefore it is summarily denied. And then he's going to be even more pissed that he wrote two very long briefs in order for them to be summarily denied in 2 pages.
Not even a show, of course. Just deny for being stupid. Fair enough. So prior to trial, I learned that Dave Neal and Megan Fox, among the JFC supporters, were planning to attend a trial in support of Clayton. It is my personal belief that the courts are publicly funded for trials, and legal proceedings belong to the public. Of course they do. I am surprised he's even pointing towards Dave Neal and Megan Fox for attending a very public and open trial. I further believe, as a matter of law, that members of the public have a near absolute right to observe and report on events which take place of the courts. Okay, let's get to the however, when I arrived at the court on the morning of the trial, I was surprised to see dozens, if not hundreds, of people waiting to watch the trial. Before the trial began, Judge Matter spoke to counsel in our chambers and informed us that she had created an overflow room for at least 50 observers to watch the trial, and the seating in the courtroom itself was packed with spectators. Judge Matter informed counsel that she had taken security precautions due to the large crowd of spectators. I found that Judge Matter's comments about the crowd surprising because prior to the morning of the trial, there was nothing filed in this matter, aside from a small number of media requests for filming that would suggest such a large crowd was likely to attend. Based on this, it appeared Judge Matter gained some personal knowledge regarding the likely crowd size that was obtained. No, wow. I'm sorry. This has got to be the throwing the spaghetti of the world and hoping something will stick. Is he actually arguing that because the people that turned up, right, that this possible collusion by the judge was made because she knew the size of the venue, so therefore she must have spoke to David Gingras' team to maybe get this idea? What is he trying to say here? Because this sounds a bit far-fetched.
So the idea is, when the day of trial occurred, we knew that there was going to be like a 15-minute pre-brief that they said. So like they said trial would start at 8:45, but the first 15 minutes is going to be in my chambers as we'd go over things. So during that period of time, when both counsel were present, the judge explained that she had made the overflow room to allow the members of the public who were able to go to see the hearing to be able to view it. Because if you look at the original, the February status conference hearing is the better video that we have, because it just shows that large pan shot over the courtroom. You don't really see multiple camera views. And in that, you see that there's basically 4 pews in the back of the courtroom. There really wasn't much room for anyone else. So that by creating that overflow room, he's saying that her idea of knowing that there was going to be some level of public appearance that was going to be more so larger than what the courtroom could take, and then also to help protect his client, because all it does is it helps ensure that she feels protected, because you know that her and Gingras would try and claim something that she was so intimidated by the number of people sitting behind her or something along that lines, that it was just going to be she already said in one of her filings that by virtue of having her ex-boyfriends sitting a few feet away from her, she was in such stress. She was so stricken with anxiety. But the video that we do have shows her, talking, laughing, being jovial with her lawyer. So she wasn't in such a anxiety-stricken disposition, at least that we can see externally.
She was also staring down her victims the whole time.
Oh, really?
Like someone who's that anxious about being in a courtroom with their super scary victims, wouldn't be staring them down the whole time.
No, I get what you mean. I get what you mean. Yeah. It reminds me of the whole thing in regards to Amber Heard and Johnny Depp. The way that Amber Heard was staring down Johnny Depp all through that court case. Yeah, that is, for someone that was terrified of the guy and scared of the guy. That is, and a victim. That's kind of a weird thing to do. On the morning of June 10th, 2024, Laura informed me that she saw Mr. Maracchini at the courthouse. Okay, sorry. At the courthouse with Clayton. The reason why I looked at that is because I know David Gingras loved to pick up typos, etc. But here's one here.
He's got quite a few in here as well.
Oh yeah. He could dish it, but he can't take it once again.
Yeah. Based on this, Laura told me she was too petrified to participate in the trial, and she told me she intended to leave unless the DVRO was enforced. Having no other available option, I immediately contacted court security and asked them to enforce the California court's order by removing Mr. Maracchini from the facilities. Superior Court security officers informed me that they did not believe that they had authority to enforce the order, and they suggested that the only option was to call 911 and ask Phoenix PD to enforce the order. Based on a suggestion, I called 911, explained the situation, and asked for officers to enforce the order. After a few minutes, Phoenix police responded. They reviewed the California's court order, and I explained to them that pursuant to Violence Against Women Act, pursuant to that federal law, they were required to enforce the California's order as written. And this is what he said he did. Despite this, Phoenix police indicated they believe they had no choice but to defend Judge Matter on this issue. As a result, immediately prior to trial, I asked Judge Matter on record to enforce the California court's order by removing Mr. Martini from the courtroom. As she had done substantially every other request, Judge Mata denied my request without explanation. As a result, Laura was forced to sit in court just feet away from Mr. Martini, which caused her to nearly become overwhelmed by fear, panic, and anxiety. So he's saying that she has prejudiced Laura Owens, and she was showing bias by this previous decision. Is that what he is that what David Gingras is trying to argue here? Brad.
Yeah, so it's not so much that it's prejudiced, but he's basically reciting all of the things that he's lost when he's made other motions, which is the motion to strike, and by trying to relitigate this and talk about it again, he's just blathering on and making this affidavit go on longer, even though it was clear in the motion to strike that you don't like the ruling, and that's fine, and you can bring it up in an appeal, but continuing to rehash and try to relitigate these matters in your briefs is just, it looks bad.
I think too,
Right.
like a lot of the motions that he had made that he's upset about being rejected were kind of like ridiculous or didn't make sense for this particular case or like what was actually happening. And like, I would imagine that seeing all these motions that don't even make sense come through and just be like super long for no reason would like annoy a judge. So like, I would reject his stuff too. You know what I mean? Like, I wouldn't take the ones that do have like something potentially worthy in them particularly seriously, because he's wasted my time so much already with all this other stuff, if that makes
Right.
sense. Like if I were a judge, I couldn't be, I'm too biased, but
Right, gotcha. Let me go back to this page. Oh gosh. Okay, so okay, so it says Laura assembled excerpts of some of these videos, which are available for viewing. It's redacted. A CD containing these videos is also lodged herewith. As usual, this may be the mere fact Judge Matter's father attended the trial. If true, it's not the primary concern. The concern is that, according to comments from Dave Neal, Megan Fox, and others appearing on the video with them, Mr. stated Judge Mata discussed the facts of this case with him prior to the trial. One such specific statement, which was made by a person named who speaks between. And do you know the video that he's referring to? By the way,
Yeah, he's reviewing
right.
to a live stream that I was on, in addition to a number of ladies, and that's the one where Hava was discussing her view, her experience being at the trial. I think that was on Rosalind Duke's channel.
yeah, I was on that one as well.
Oh gosh, I wish you was here to see that. Oh wow. So
I was in another, so he put together a whole compilation to try to support his idea that her father was there, and that's horribly biased. Now, like, I was in another part of that compilation video, and I spoke about this on Lauren's channel. He just assumed that I was talking about her father. I didn't even hear anything about her father until I was already out of the courtroom listening with everybody else, like talking on Dave's stream. So like I was talking about a completely different human. So this is the level of research that he puts into stuff. He doesn't fact check anything, because I literally wasn't even talking about her father at all. I was talking about someone who was young enough to be her son. Like, what? It did not make sense. So I don't trust literally anything that he posts. Obviously, Hava said what Hava said. Like, you can see her saying it. It came out of her mouth, and she specifically said father. But just because the word he comes out of someone's mouth doesn't mean we're referring to her father.
So basically, he can't even do sleuthing properly. That's
Correct. Yeah.
that's funny as well. Right. So in the course of making, so this remarks that he's referring to, So basically, he is trying to demonstrate that the remarks and everything that you guys were saying on that stream was indicative of the bias by presented by the judge.
Yeah.
Yeah.
That's okay. That's a leap and a half, but
By her
sure.
father showing up at a public court hearing that he is a public citizen and is
Okay.
allowed to watch.
Okay. Wow. Okay.
And
And
then we have Brewster Morgan did a video recently and said that he has come to receive some knowledge from a person who was at the trial who happened to have printed off particular documents and handed those documents off to who may have been Judge Mata's father. And if that's the case, then that particular person, when he stated, or when Judge Mata's father stated that have you seen these documents in that statement, we assume that he was mentioning his daughter, but the person who had those documents and gave them to him is likely not Judge Mata, but that's how he got a hold of some of these documents. But in this briefing, he makes it seem that Judge Mata had printed off these documents, even though they're public records, and gave them to her father to read.
But again, we don't even know that was definitely her father. Like we really have no verification. So like, yeah, he's like potentially very wrong on both counts. And it's just ridiculous that he states it like it's an absolute fact.
Right. Also, just want to take this moment to say that we are halfway through, guys. When I say halfway through, I mean like we are legit halfway through into being monetized on the channel. As we can see here, we are 227 subscribers and 1,500 public watch hours away from being monetized. So tell everyone about this channel. Let people know that what we do over here, because all we do over here is trial talk as well as going through filings uh and discussing cases like this. I'm providing updates, etc. Just like in a real courtroom. That's why it's called Ketchup Court after all. So yeah, make sure that you guys are subscribing and watching the videos. It would really help us out. Uh, get monetized. Also,
Hit that
so
like
yeah.
button.
Yeah, that thank you so much, and also hit that like button. Thank you so much, Hellville. So yeah, going back into the affidavit by David Green, Gangrene. In the course of making these remarks, Miss I don't know who that is. Redacted also made statements which appeared to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. I'm sorry, this has to be a joke, right? Like he actually says that that he has proof that
so
that the
both he
judge
and his
was
client keep claiming that they have so much proof, none of which is ever like objectively verifiable ever. Like it's their game. They always claim it and they never have it. Where's your proof?
Have mountains of evidence.
Yes, exactly.
I can see why you looked finished, Brad, because I can tell that you've been here before. You just like, oh my god, I can't believe he's doing this again. Because like for you to have proof of it's such a high bar as well. I mean, think about it. Like you have proof. You say you have proof of the judge doing something like deciding a case before he even saw it. Like that doesn't even sound true. Even if you want it to be true, it doesn't sound true at all.
Yeah. And the standard for this is clear and convincing evidence. So it's a very high standard that he has to meet.
Yeah.
And none of it is clear or convincing.
Yeah, I mean I mean, it's not a great or convincing start when you say appeared to imply. That's just saying that it's not what it's saying. It's just not what's happening. It's just anyway. Moving continuing on. It says the discussion of that point is brief and not entirely clear, but my belief is
Well,
based on my belief source. My source is based on my beliefs. I should say. Anyway, moving on. So, but my belief is based on Miss Redacted's claim. Mr. Redacted whipped out papers that Julie printed for him. Then she mentions Laura's request for findings of fact and conclusions of law, finally asking, "Did anyone see those were denied prior to trial?" What is also extremely disturbing is that in the video compilation, upon hearing remarks regarding Judge Matter and her father, Dave Neal laughingly commented, to paraphrase, "Hold on, we don't need a mistrial." That's the silver bullet that's gonna do
He's a
it. That's gonna
comedian.
get that over the line. Sorry, go on, Elvin.
He's a
What were you
comedian.
gonna
Of
wild.
course he joked.
say? There it is. That specific comment from Mr. Neo appears between about in the above video compilation. I understand those remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding comments they claim to have received from judge. It sounds so ridiculous. I'm sorry, it just sounds so ridiculous. I'm surprised it's actually made it into a
Because it
filing.
is.
That is so surprising. It
Well,
just sounds, it stinks of desperation. Sorry, Hellville, go ahead. What were you gonna say?
I was just going to say, if Dave Neal were a lawyer and potentially involved in this case, or, you know, what in whatever capacity, or just reporting on legal stuff, and he said, "Oh, careful, we don't need a mistrial," I would take that with a whole lot more weight than, like, I mean, you know, forgive me, Dave, you're absolutely brilliant and very funny, but you're a comedian, you're not a lawyer. This is the first suit that you've ever, like, you know, reported on, and like him saying that clearly was a joke, and it doesn't hold any weight. So it's the most ridiculous thing to put into a freaking filing.
Right. Absolutely. Absolutely. Bruce from Oregon, thank you so much for tuning in because Dave is a mistrial expert.
Yeah.
Roy Lunsinger says nothing is inviolable if nothing is viable except for our own name. And even then I question, I mean, who is Laura Owens or Laura Owen? Which one which
Or
one
is
is
it
it?
Laura Owenstein?
See.
Or is it
See.
Emily
Not
Wilson?
exactly. Not so verifiable now, is it?
Or is it tag?
Is
Or
it, Ron?
Yeah, or is it Tag or Chase J. Jones or Robin Chang?
yeah,
Who else did she impersonate? David Katz?
Lisa Chen and
Yeah, Lisa Chen, that's the one.
Robin's the actual one.
Sorry about that. Gingras goes on to Roy goes on to say Gingras knows his case is lost and is trying to get all the money he can from a client he knows has mental issues. Yes, that's right. We actually did go through that in the previous stream as well. We actually discussed this. I did not know that he actually felt that this was a lost cause because he believes that Laura Owens has mental issues. I didn't even know that was the case, and then I learned that in the previous stream.
Yeah.
You can go see my reactions in that stream. You can see.
But having mental issues is not the same as being of diminished capacity. I believe she's fully within her right mind. It's just that she's evil. I'm not even joking.
This is coming from Hellville. This is coming from somebody called Hellville, by the way,
Yes,
guys.
so it takes one to
And
know one,
she
okay?
recognizes the evil.
Exactly. I'm an authority on this. I do, though. I do think that a lot of it is manipulation tactics. And I think that people who are saying she's of diminished capacity and he's still representing her and doing her bidding, blah, 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 and it's morally reprehensible. I disagree, just because, I think that it's easy to say that if you haven't been manipulated by someone like that. But I think that if you have been the victim of this type of manipulation, it's much easier to see that this is a type of manipulation, and she's not of diminished capacity. She knows exactly what she's doing. She's just too dumb to get away with it.
Mm. Mrs. Brightside 15 says your laughing is contagious, Dr. Hines. Thank you so much. Oh gosh, thank you. I appreciate that. Let's get back into this. Attempt to save his its case. It says assuming Josh Matter did in fact share information. It's not assuming. That just didn't happen. Share information about this case with her father. That conduct would appear to be a per se violation of Rule 2.9A of Arizona Code of Judicial Conduct. I don't know what that code of conduct is. It's most likely going to be you cannot share information with someone with a third party outside the case or something like that. I have no idea. Despite these allegations, my personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable, and I considered the possibility that the claims made regarding Judge Matter's father may be fabricated, either in whole or in part. What was the point then? If you think that the Judge Matter's father is fabricated, why are you I'm confused, man.
And he made a whole video compilation using our words.
Yeah,
but we're not reliable.
Confused me.
And he put it in a legal document, but we're not reliable. What?
I don't get
Either
it.
we are or we aren't. It's just like this is complicated or it's simple.
What I'm trying to say. Why are you quoting them if they're not reliable? But you just quoted them as if they're truthful. but how reliable are they? You just told us that you just spend your hours watching these guys in this live stream for you to quote and do all these things, and then you just told us, by the way, they're not reliable, so you can't believe anything that they're saying. What was the point then?
Meanwhile, we have found all of the irrefutable evidence. I mean, not like we collectively as followers or as reporters have found all the irrefutable evidence in this whole entire case, and he has presented nothing but fake crap. So it's like, I mean, who's reliable here, realistically? Yeah. I think it's us. I think we win.
It's not even. I just don't know why he would use you guys if you guys were not reliable. That just doesn't make sense to me at all. I just doesn't.
None of it makes sense. None of it. From page 1, it does not make sense.
Right. Okay. Given how serious the issues were, I did not believe I could ethically make a formal accusation of judicial impropriety without taking some reasonable steps to verify the truth of what happened. In an effort to ascertain the truth, while on vacation on the morning of June 17th, before I received the post-trial decision, I sent an email to Judge Matter's division in which I raised concerns regarding Judge Matter's father and the alleged statements made by Dave Neal and Megan Fox. At that time, I had not yet seen Ms. Darby's remarks. A true and correct copy of this email attached here to Exhibit B. In this email, while noting the unusual circumstances, I asked Judge Matter to promptly provide a response to the allegations regarding our father. I further explained that if the allegations were true, I believe they may support a change of a judge for cause. A few hours later, I received an email response from Judge Matter's division stating, to the extent that the party wishes to bring a matter to the court's attention, the court respectfully asks that you file appropriate motion, etc. Blah blah. About 14 hours later, on the morning of June 18th, I received the court's post-trial ruling on the merits of the copy, which I attached herein. After reviewing, and I noticed something. After reviewing June 18th decision, which found in favor of Clayton as to virtually all issues, Laura and I immediately noticed something truly shocking. The ruling contained findings that were not based on any evidence at trial. Instead, those findings were clearly copied from posts on social media. Specifically, and to cite just one obvious example on page 10 of the decision Judge Matter made, certain findings that were purportedly based on the trial testimony of Clayton's medical witness, Dr. Samantha Deans. Dr. Deans is an OBGYN who previously worked for Planned Parenthood on East Coast. As it was, that's what it
She was a
shows
director.
here.
Yeah.
Yeah. Without laboring the details of the entire history of that issue, the question of whether Planned Parenthood was or was not open on Sundays was relevant and extremely important. This is so because at trial,
You
Laura
see what
testified. Huh? Sorry, go on.
the thing, the belaboring of the details there is my client changed her testimony on the day of trial, so I'm going to ignore that completely relevant fact and just give my side of the story, just scooching right past that.
Oh gosh. This is so because at trial, Laura testified she sought care from a Planned Parenthood location in Southern California on July 2nd. As it happens, on July 2nd, 2023 was a Sunday. Therefore, if Planned Parenthood was not open on Sunday in July 2023, absent some other explanation, that would appear to disprove Laura's claim that she sought care on that day. But here's the problem: Dr. Deans never testified about this issue at 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 trial or any other time. I've got a question to ask. This error here about the Planned Parenthood being open on Sundays, was it so bad because of the fact that Laura had put down on the forms by the Planned Parenthood or whatever they had put down that was the actual date, or was she just too lazy to just say, "Oh, look, I just made a mistake. It's actually the next day. It was meant to be Monday, not Sunday." Why can't she just say it was meant to be Monday, not Sunday? Why is she committing to this? So why does she have to commit to this Sunday thing?
So the problem comes from a number of facets. One is that this goes back to the Planned Parenthood sonogram, which she admittedly changed the name of the facility from SMIL, Southwest Medical Imaging Laboratory, to from Parenthood to Smile, and then also added her name and changed the date because the date that she had there was June 7th. Then she said, but I actually sought care on July 2nd. And the reason for that is she was at a horse show in Southern California at that time. So the only way for her story to be semi-plausible was that she had to have been in California around that date, which she was for her horse show. The problem is that getting an ultrasound and doing a horse show, you can't really do that in a short amount of time because from other evidence that she had that we've discovered, she spent at least 3 hours in prep for an abortion, at least another 3 in actually going to the room, sitting and waiting to get called back, things like that, and then ended up getting a supposed medical abortion with her prior ex-boyfriend, Mike Maricini. And so it's not just the Sunday is inconvenient for her, but it's a matter of it. One, she was in Mission Viejo because in that area of Southern California was where her horse competition was. And then to say, well, no, it was actually in a different spot that was also in the same region, or because she's reported 2 different locations. It was like Mostikai, or I can't remember the name of it, but it was within that same region of San Bernardino and Orange County Planned Parenthoods, which are open on Sundays. But then she changes her testimony that she's had for 6 months or so. It's going back a long way, because that's one of the things that they discovered at her deposition in the beginning of March, was that they were trying to pin her down on, well, did you go to Mission Viejo? And she goes, yes, I went to Mission Viejo. I didn't change the sonogram itself. I only changed the name and the location. And then they put in the HIPAA records release and say, well, give us all your information. They said, well, the only thing we have is there was a maid appointment that was canceled. And that was the only piece of information. It's like, oh, well, that's because I went to Los Angeles. And it's like, well, you couldn't have gone to Los Angeles because, 1, that's like an hour and a half drive just to get from Mission Viejo up to Los Angeles. 2, they were closed. So it's like she just keeps digging herself in by trying to do everything she can to skirt around just taking responsibility for the fact that she didn't actually get it. If she would have come clean and said, I didn't get it, I lied about it, and taken her lumps, then things would be better for her. But she just continues to do this and dig her heels in because she's being an obstinate child.
I'm so glad I asked that question now, because the same way that you just put down there, as she just come out and just said XYZ, I didn't do it. Okay, I didn't do it. It does sound a lot more simpler. It just sounded like there was a much simpler explanation in regards to all of this. And thank you so much for providing that context, because that was a lot simpler than what we just read here in regards to what you said. So moving on, by the way, just to read this chat quickly, it says Roy Lunsinger says, I'm surprised that Judge Mata hasn't referred Gingras to the Bar Association over his writings. I'm surprised as well. I'm actually surprised as well. I hope so. I really hope so. Right. Okay. So let's go back into the transcript. Sorry, not transcript. Into the affidavit. So it says, as the transcript clearly shows, at no time during her brief testimony. That's the transcript, by the way. That's his exhibit. But it says it clearly shows at no time during her brief testimony did Dr. Deans or anyone else ever address the question whether Planned Parenthood was or was not open on Sundays. Okay.
Right. She didn't. That is correct. That's the only thing he's ever said that's correct. But it could have been in her expert report that he published part of and not all of.
Yeah.
Right. If Dr. Deans did not testify that Planned Parenthood is not open on Sundays, where did Judge Mata come from? Honestly, and I said this in the previous stream. By the way, let me just read this out before I just make this point right here. Hey, Bells, thank you so much for this chat. It says, great job explaining all that, Brad. Such a mess that she has created. And this is why I love having you guys here, by the way. Sorry, Brad, go ahead.
No, I was saying thank you, Hey Bales.
Yeah, this is why I love having you guys here, because I just know that there is a mess somewhere. There is some kind of omission somewhere.
There's horse droppings everywhere. It's just you can only tiptoe around them so much.
I was trying to be polite. There is horse. He's right though. There is horse dropping everywhere, and you you kind of need to be told, hey, watch out for that. So what I was saying here was, in regards to this, into this testimony, if Dr. Deans did not testify that Planned Parenthood is not open on Sundays, where did Judge Mata's finding on that issue come from? If Judge Mata knows for a fact that, and I said this on the previous stream, if Judge Mata knows for a fact that the Planned Parenthood is not open on Sundays, she can rely on that information. It's the same thing that the juries are afforded with their life experience, all those things. this is what it covers also. I'm surprised he's
Personal
making this
knowledge
argument.
is admissible, or well, not really admissible. It's able to be considered as part of that.
I think you're
Right.
also allowed to check on a common fact. So checking if a Planned Parenthood is open on Sundays in the area that was only just disclosed on the day of trial, I believe that would be considered checking up on a common fact that she had a hunch on, which would be very fair. But maybe shouldn't have been attributed to Dr. Dean's testimony unless it is in her report somewhere that we just, they pick and choose what they share.
Right.
Because there's one thing for Planned Parenthood's hours to be published and say, well, we're open 9 to 5 Monday through Friday or Monday through Saturday, and then they list as being closed on Sundays. But then if for whatever reason, say, take this the facts in this case and set them aside for a second and say, well, but Amanda Bynes, very popular Nickelodeon star, childhood star, for whatever reason, contacted Planned Parenthood and said that we needed to, she needed services and she needed complete anonymity and needed to be let in under the cloak of darkness, and we needed to open up at 6 a.m. on a Sunday so that no one would reasonably assume that they were there for whatever the reason. That would be a fact that would be so particular that it wouldn't be common knowledge, because nobody would know that Planned Parenthood on that particular day was open for the explicit purpose of allowing her to receive services on that day. But if the publicly posted hours of we're open 9 to 5 Monday through Saturday and we're closed on Sunday, that would be considered common knowledge because it's posted on their website, it's posted on their front doors, it's something that you come to expect on. And
Right.
it's only deviations from that where you would start to get into issues. It'd be like, well, another example would be, say you're trying to discuss a some case, and they go, well, they list that they're open from Monday through Friday, 9 to 5. And then they go, but we had a water main break and we were closed for that particular day. You'd be like, oh, well, that's different. That would be some reason or rationale. You would need to have evidence to show that, because, or taken judicial notice of that exception, because that wouldn't be common.
Right. Right. And
But either way, the records would
Go on.
still be under her name. Like,
yeah, they should.
So like they would like admit her, I believe, under like a pseudonym, but ultimately their notes and everything would be on her real name, I believe, right? So
right.
But I understand what you're saying. It's not common knowledge if they happen to open on a particular day because she's a celebrity, which she's not, by the way. Well, she is. She's a public figure, but not a celebrity.
But
yeah,
but it's when you get into those particulars where if you're trying to determine whether or not some hours of a location are open, that's not a material fact in the case. There was talk about the ABA, the American Bar Association, posted a hypothetical question and said that if a worker is attempting to get overtime hours, and the finder of fact, the judge at the time, went to look at or to Google the hours of the location to assist in determining when or what the opening or what the hours of the location were, in order to determine whether or not they were going to be afforded overtime for the amount of hours that they were given. That would actually not be allowed, because that would be a material fact in the case. But because this fact is more tangential to the case at hand, it then becomes less of a concern.
And there are 45 other reasons that she gave for finding, for ruling the way she did. So it's not like that was the only reason that she ruled against Laura. Like, there are so many other reasons, and that is such a minor one. I mean, she perjured herself on video on so many other occasions that I'm sure we could all count. So, it's just, that was just one small piece of it. So it's not like the main thing that this whole ruling is hinging on.
Right. Right. And just to add on to you guys' points overall, let's just be honest. It's like, the same way that Bruce from Oregon said last time, math. Like, everyone just knows math. And if you go
Right.
on and if you go on the stand to say that 2 + 2 = 4, he didn't say this part. This part is just me. But like, if you go on the stand to say 2 + 2 = 4, you're not gonna get be caught and hearsay exception being thrown at you, is it? Like, just for saying 2 plus. It's some things are just facts.
Right.
Like, this is what I was saying on the previous stream. Like, if it's just fact, even if the judge did use this outside information, even if it actually is within our right, regardless, it really is. Because if she knew that this has always been like it will always be it's part of our discretion. You are allowed it to use your. I don't know. I still don't see what the judge did wrong here, but anyway.
It still could have been in Dr. Dean's report, though. So she said it's in Dr. Dean's testimony, but at the same time, I would think that the report was submitted well before the court date, which is when we found out that she was supposedly in Los Angeles. So if it wasn't in her spoken testimony, then I guess it is moot. But either way, I mean, it's verifying a fact that she had a hunch on.
Gingras likes to forget all of the things that happened before he came out of the case, and for whatever reason, he also likes to forget that any motions that were filed and evidence that was presented during those motions are considered as facts of the case. In addition to the requested judicial notice of the Maricini case or the Gillespie case, in addition to bringing in the order of protection hearing from Judge Duty and the injunction against harassment case, which were brought in for the purposes of fees and costs. So she's seen a ton of evidence regarding this case. And now that we're here at the end, and now he's saying, well, because this amount was talked about during trial, that's the only thing that can be discussed. No, that's not the case.
Right. As noted above, during the course of my involvement in this matter, I have published a small number of comments, approximately 15 posts regarding this case on my personal website. This is a tiny, insignificant fraction. It's not tiny and insignificant because it's only been a year that since he took on, isn't it? It's only been like a few months, like 5-6 months, isn't it? Am I wrong with that? 11-12 months?
So it first went to the media in, I believe, September. I know I started following this whole thing in like around then. But I mean, the actual intimate act acts, I should say, there are two of them, were performed on May 20th.
Okay.
Last year. Yeah.
Gotcha. All right. This is a tiny, insignificant fraction of the commentary published by Clayton and his followers. As noted above, the Justice for Clayton Twitter account posted nearly 3,500 tweets about this case, and a number of other posts on social media is certainly in the tens of hundreds of thousands, if not millions. Freedom of speech, baby. Freedom of speech. I don't know what to tell you. As limited as my online involvement in this case has been, I believe Judge Matter conducted our own independent research into the facts of this case. Listen, the same way that I said in the previous stream, hopefully he has the FBI level kind of investigation that case that he cited for his own to support his own motion. Brad is shaking his head, but the case that he was citing. I'm surprised he hasn't presented that, because that case was quite confident that judge was acting purely from purely from independent research. Why do you think and this goes for you, Brad? Why do you think that he is stalling in presenting this information, this exonerating information that would completely obliterate Judge Matters rulings? Why hasn't he presented anything yet?
The evidence is that she made the finding of fact. That is his evidence. The idea is that she wouldn't have had that knowledge unless she was checking the social media pages, his blog, or anything like that. That's his evidence, and he's hanging his case on that rather than trying to say, here is the evidence of the sonogram from Los Angeles, because that it actually involves him doing investigative work and then discovering that his client has lied. Here, I've got a button for that.
She lied?
And unfortunately, it's critical to his case is just not investigating his client in order to determine that she is in fact lying. Because if he does, then he's got a whole bunch of statements that he's made that would be really terrible for her case.
Right. Okay. Wow. I can't believe she's lying. Okay.
This will get awkward.
First,
Love the Greg Woodnick sound bites.
First, throughout this case and repeatedly at the trial, Clayton's counsel, Greg Woodnick, vociferously complained to Judge Mata about the fact that I was making public statements about this case through my website and Twitter. And Mr. Woodnick specifically provided copies of articles I wrote and posted on Redacted about this case. I found Mr. Woodnick's complaints in this regard confusing because the information and comments I posted about this case were not improper in any way, and because Clayton and his supporters, including Mr. Woodnick, had also posted public comments online about this case, suggesting that Mr. Woodnick fully understood I had a right to inform the public of Laura's side of the story. Based on what I know now, I believe that by pointing to comments on my website, Mr. Woodnick was not actually concerned about the contents of these posts. Instead, I believe he was suggesting or hinting to Judge Mata that she would go online and perform an ex parte review of my site, and I believe that is exactly what she did. That belief is based on the fact.
I think that he was more so suggesting that Gangrene is unprofessional, rather than trying to drive traffic to his ridiculous blog. And Woodnick really only put that in two motions that he was like publicly posting. Like it was only in one or two motions, I believe. Mm-hmm. So it's not, when he says the word vociferously, that word also doesn't make sense here. And it was used as like a supplemental thing, not even like the main crux of whatever argument Woodnick was making at any given time. So it's like, once again, get out your dictionary before you use big words you don't understand, David.
And before you claim that words don't exist.
Yeah, that too.
And right, and this is the meaning of the word. What is it called? Vociferous. Expressing or characterized by vehement opinions, loud and forceful. And I see what you mean, because I do not even understand why that had to be included the way it did. Considering the context of what he's talking about. Anyway. Anywho.
Meanwhile, he's the one that's vociferously claiming all these things based on the definition. Very forcefully. Right. Very forcefully.
Right. So maybe he was projecting. Maybe he was just projecting.
I wish that was the case.
Probably
so. That belief is based on the fact that immediately after Laura finished testifying at trial, literally later the same day, anonymous supporters of Clayton began posting comments on my website, also on social media, asserting Laura committed perjury when she claimed to have sought care from Planned Parenthood on July 2nd, 2023. Because that day was a Sunday and Planned Parenthood isn't even open on Sundays, this specific comment was posted by an anonymous user on my website on June 10th, 2024, a week before Judge Matters issue a post-trial decision. Don't tell me he is going to say that the anonymous user is Judge Matter. Dun, dun, dun.
No. It's
Sorry, go
not
on.
even that. It's just that she went to the website after the trial and saw the comment and was like, oh, and then attributed that fact to Dr. Dean's.
She could have also just Googled it.
I don't know, man.
I mean,
They're
there's no
saying-
proof whatsoever that she went to his website.
If they again, this is just get the search history down and see what happened. Anyway, the evidence supports two conclusions. First, Josh Matters finding that Planned Parenthood is not open on Sundays did not come from trial testimony of Dr. Deans, nor did they come from any other witness. I would love to read the order by the judge now, by the way. Indeed, the word Sunday does not appear anywhere in the transcript. That much is beyond dispute. Okay, I see why he posted the transcript the way he did before. He just wanted to show that Sunday did not belong there. Anyway, second, the evidence shows Judge Matter violated Rule 2.9c by performing a secret, undisclosed investigation in the facts of this matter, which clearly would have resulted in her seeing comments from Clayton's supporters regarding their beliefs as to Planned Parenthood's hours of operations. The fact that Judge Matter based her post-trial ruling on anything other than the admitted trial evidence demonstrates beyond a preponderance of evidence that grounds to exist to disqualify Judge Matter from this matter. That rhymed. On the basis of bias and prejudice. The same is true for Judge Matter's decision to have an ex parte discussions about this case with her father. Okay, so that's it. That's the affidavit. Jesus Christ, what are your thoughts while I load up Dave Clayton Echard's response to this? IT Goatee.
So the biggest thing about this is he's making all of these claims about Judge Mata and her what she's doing during the trial or before the trial. So we're going to get an interesting response from Clayton's lawyers in Greg Woodnick, and on when David posted the document on X, he said Clayton didn't even argue the merits of my motion, and it's like, well, okay, but how is Greg Woodnick going to know anything about the personal life and comings and goings of what Judge Mata did before the hearing? He wouldn't have. So how can he argue in any position on those points? The only thing that he can discuss is what he ends up writing about, which is that it was untimely, and that was it.
Right. Hellville, did you have what were you gonna say? Sorry.
Oh no, I was gonna say, yeah, he didn't argue the merits of the motion because there are no merits in the motion. Like literally none of it is fact. It's all opinion based, even though he's stating it like it's a fact. Just because you say it like it's a fact doesn't make it a fact. I mean, you know, this has been his tactic kind of the whole time. He just tries to force it down your throat. Sorry for the visual there. I'm sure Clayton is a little, scarred there, but he's just trying to shove it down your throat to force you to accept it. But the thing is, like, most of us following this case, we see it for what it is, which is fraud. So, like he's trying to force more lies and potentially like coincidental evidence or whatever, like down our throats without verifying literally anything before making these assertions. So it's just more ridiculousness based on his, his ego. I think it's mostly ego driven, honestly.
Yeah. Yeah. No, I hear you. I think let me try and find it. I think that's not this one. I'm looking for. I think this is the one. Oh. Okay. Um. Oh, no. I think I found it. Okay, this is what I was looking for. So this is. Oh gosh. This was the response by. Hold up.
Yeah, it's
I
like 4
thought.
pages.
Yeah. The response by Clayton Ashard for the fees, and
Nope, that's it. That's you just got to scroll to the top.
oh, okay. Let me. Oh, okay, cool. Yeah, that's the one. Okay. Gosh, not my smartest moments, but yeah, this is the final. This was the final response in regards to the notice to change the judge. It's just legal arguments to say why this is wrong, etc. But I don't even think that the judge is even going to rely on this to even make a decision of saying no. I think she's going to say no and just say, "Look, I don't care. That's just not what happened
So
here." Go on.
the funny thing about this is one thing that David Gingras ends up posting is that there's a 2-page limit to a response for a notice of change of judge for cause, and Greg did not ask the court for leave to be able to post a longer one. So you could run into a case where Greg's response is denied due to exceeding the page limit, and then Gingras's motion is also denied because it has no merit.
But also, how do you respond to a 211-page motion? And I know that a lot of it was just testimony or whatever, but how do you like reply to that in only 2 pages? I mean, isn't there a limit on how many pages the original motion can be in the first place?
I don't think so, because it's attached as an exhibit. It's not part of the motion itself.
Oh, okay. Okay. Well, that's
He's just trying to
literally.
like get out of things on technicalities.
Oh yeah, that's all he's trying to do, and then he's
It's
trying to.
just not working.
He's hoping that he can get away with what he did in the dirty.com stuff, which is why he keeps referring back to it, in that he keeps throwing out all of these technical reasons for why things should be going his way, and then he's hoping that he can get into appeals will agree with him, and then he gets vindicated for his terrible behavior in these first stages of the trial, because he believes that he can win on appeal.
But even if he wins, his behavior was still reprehensible for a lawyer. So
Absolutely.
that doesn't vindicate him of being in trouble with the bar anyway. But like the whole thing is just it's so ludicrous that he thinks that he can win this whole thing on a technicality when he doesn't even fully read through the actual technicalities. Like we saw that when he posted Mike Maricini's testimony from his deposition, where he's like, oh yeah, I got him based on this line alone, but then didn't continue reading because a few sentences later he said something completely that refuted whatever Gingras was trying to argue. So it's like, well, you didn't really finish the whole thing there, buddy. So it just negated everything that you're saying with your technicalities.
Yeah, that's pretty much I think we have only got like 5 minutes left of the show. So yeah, that's pretty much all there is in regards to the affidavit as well as the motion, as we have just learned today that well, literally just learned on the stream that the judge had denied one of the orders. So
That's the one we didn't even read.
Yeah.
Oh, is that the? I think I've got it up here. Is that the one that Laura made on the 8th of July in regards to the fees?
No,
It's a
this
4-page one.
No, Laura didn't make anything about the fees.
Oh
This would be
no. Sorry, Clayton. Clayton?
No, this would be on the one that was filed after Gingras's motion that you had just read, which I believe was filed on the 10th, and then he did one on the 12th as well.
No. Okay. All right. Yeah. We haven't read it. Okay. Well. Damn. I didn't even know. Okay. So I didn't even know that one. All I was aware of was this particular one.
Yep.
Where he was uh claiming the bias, etc. So what's that particular motion about then?
It's rehashing the same things, just saying that because of Judge Mata's bias, we're requesting a new judge. We want all of the orders that she made vacated, going back to when Gingras first came on, and even before then, actually. If I can pull it up real quick.
Yeah, before then.
Because one of them, it's funny because he wants the order vacated for the request for lunch, which is even funnier.
Oh God!
And then
All
he
right.
lists 26 reasons what or things that he believes are appealable issues that he's trying to get in, because when you go for an appeal, you can only go on things that have been presented in your first trial. You can't bring up new issues on appeal. So this is his attempt to preserve all of these pieces as appealable issues.
Brad, did you say 26 arguments?
Yes.
That's his favorite number, because Rule
Is it?
26 and 26 arguments. I mean, the number 26 never goes away, does it?
No, it doesn't.
It's gonna be a while for me to get that joke, folks. It's gonna be a while for me. Yeah, I haven't been in this for that long. But yeah, let me just read out a couple of chats and then we'll bring this. And then we'll bring this to a close. So before moving on, because it's not bothering me now, because I have to find the order and now read it and see what it basically says.
It's
hopefully-
literally a one page that just says denied. So
It's super
it's
short.
not like it's anything that you're missing out on.
Oh wow! So it didn't even include legal arguments or anything like that. No,
it's just like denied.
That's literally that just means your argument was so bad. I can't even. It doesn't even require a response. Everything has been denied by. Okay.
Because the problem is he's going to have to take the judgment to appeal. So whether she denies it with a full briefing or just does a one page, he's got to appeal it based on the facts, not by trying to get through these technicalities.
Right. Okay. So I think that is it. Thank you, every single one of you. Hellville, thanks so much for joining me. You're ever so cool. And IT Goatee, thank you so much for returning as well once more. I appreciate both of you for providing the much needed context into this case. Yeah, like what do you have going on this weekend, IT Goatee? And then we'll get to you, Hellville.
I will be on the panel show with Legal Vices tomorrow evening. He's doing an F at Friday stream. In addition to, if we get more information on a potential ruling on the matter that we just read about, hoping for some actual legal briefs on that one as well, then there probably will be some snap streams going on between Megan Fox, MG Law, and others. And I also have to read the motion to vacate in my dramatic reading style. So I've been pushing that one off as much as I can, because that's 32 pages of dramatic reading that I need to get through.
Right.
Just save your voice, have some tea with honey, and you should be okay.
Yeah.
And you can check out IT Goatee's channel. It is going to be in the description. Yeah, so you can check him out for all the new subjects coming out. Hellville, what about you? What you got planned this weekend?
I'll probably keep up on most of the videos that drop. This case, as you've probably noticed, can be a little bit overwhelming to be to be too immersed in it. So I'm slightly burnt out, hence all the fire. But yeah, I'll probably be in the Hamptons this weekend, honestly. So
Oh, look at me.
yeah.
Oh, nice.
I don't
nice.
really have a channel. Like I have a channel that exists, but it doesn't have anything on it. So maybe in the future. But
Yeah, well,
yet.
you need to get a start on it. That's the one. That's what I was looking for. I don't know what. So what? Anyway, you need to get a start on it because before you lose your JFC coach status, you might lose that. You might, So if you don't want to lose that, you need to get on it. Right.
I thought it's a lifetime membership. Do they revoke the cult status?
You don't forget to pay your dues as well.
Oh no, I don't need to pay the dues.
All right. So yeah, we will leave it there. We'll be back on here this Sunday to recap a lot of the goings on in regards to the trials for this particular week. The Swan Lake trial has gone on. Swan Lake. Oh my gosh, no, that's not what I was going for. Black Swan. That's the one. Black Swan trial. The Black Swan murder trial is on the way. So we are going to be discussing a few details from that trial this Sunday, and also just whatever update in regards to Laura Owens that comes out. We will also discuss it this Sunday as well in the live stream that's happening. This Sunday at 6:30 as we usually do. So once again, thanks guys for joining. Hey Bells, thank you so much for your contribution in the chat. Bruce from Oregon, I appreciate you as well, and every single one of you in the chat. Solo Dove, Random Girl, Mrs. Brightside, Roy Lonsinger, and anyone I may have forgotten. I appreciate you for using the chat. And I will just leave it there. Thank you so much, Brad and Hellville. Have a great evening.
Yep.
Take care. All right.
Thanks.
Bye-bye.
Have a good one, everyone.
Bye bye.